and we're so glad you did. We have 4 cases on the docket this morning. After the 3rd case, we will take a short break to alter the panel a little bit, but it won't be long. Appellants, when you come up, please let us know if you wish to reserve any time for rebuttal. And let's see what else is on my list of things I have to say. Remember, we're in a new era where things go on the internet. Now, we live stream these proceedings, and they also stay on the internet. So think about what you say before you say it, because once it's out of your mouth, you cannot get it back, and it will be out there forever. With those items, are there any announcements? Seeing none, would you please call the first case?
Rebecca Hudson et al. Versus Paul Gravette et al.
Good morning, Your Honor.
Morning.
My name is Brian Dunnigan. I represent the appellant, Rebecca Hudson, in this case. I'd like to reserve 2 minutes of my time for a brief rebuttal.
2 minutes, okay.
This case is about whether the Tennessee dog bite statute, TCA 448413, eliminates a dog owner's absolute common law liability for an attack by a dog that the owner knows is vicious. The facts in the record, the Gravettes knew that these were dangerous dogs. They knew. Before the attack in this case, they boarded the dogs at another facility. Dogs attacked 2 girls there. The facility banned the dogs from returning. The Gravettes then take the dogs to Chasing Tails Pet Farm, the boarding facility in this case, board them there. No warning whatsoever to Chasing Tails or to Ms. Hudson. Ms. Hudson gets attacked. The dogs nearly kill her. And the trial court held on these facts that since Chasing Tails boarded the dogs frequently, that the Gravettes put their dogs there frequently, that made Chasing Tails an owner of the dogs, and in turn made Ms. Hudson an owner of the dogs. And thus, taking another leap, the Gravettes are immune from liability because they're title owners, and the Chasing Tails and Ms. Hudson are statutory owners. So if you take that line of reasoning and you take it out on the street to a layperson out here and explain that to them, they're going to say, what the heck? And I would submit that if you took that line of reasoning in 2006 to the legislative debates in this case before the General Assembly, they would say, what the heck? And this court has to decide whether the legislature intended that result. We would submit you can't get there from here. Now, there's 3 foundational points to our case that I'm presenting to you this morning. The first foundational point is the common law, and that's a basic first-year law school principle that we all know. If you own a dog and you know the dog is vicious, you're absolutely comprehensively liable for, quote, any injury which such animal may do to another person. That goes all the way back to 1914 in Tennessee in Missio versus Williams. It goes all the way back to common law England in the underlying law. And that's one of those fundamental rules of public policy that we get sometimes from the common law. If you, as a dog owner, know your dog is dangerous, that it presents a danger to the community, you have a choice to make. You choose to keep owning that dog, then you own the responsibility if that dog hurts someone. And that is the choice in the policy decision in the common law. So we start from that principle that if this case happened under the common law in 1895 or 1914 or 2005 before the statute, then you have absolute liability for an attack by a dog that is known to be vicious. Defendants would be liable. Second foundational point. The dog bite statute, 448413, is a statute in derogation of common law. It changes the common law. So the rule that your honors have is under Davenport versus Chrysler Corp., under Jordan versus Three Rivers Baptist, statutes in derogation of common law are strictly construed. The case law quotes, these statutes do not alter the common law any further than they expressly declare. Another quote from Jordan, there is a presumption against a legislative intent to change existing law. In other words, statutes in derogation of common law do not have unintended consequences. You cannot abrogate the common law by implication. So when the trial court below says in its holding, in its order, that the result in this case, in its holding, quote, may not have been the intent of the legislature, that is a red flag. That's contrary to how your honors must interpret a statute like this. You affect the legislative intent. Courts affect the legislative intent.
Counsel, let's
Yes.
talk a little bit about the statutory language here specifically. In terms of owner, legislature chose to not use title owner. Instead, they defined owner in a different way.
Right.
Who is somebody who falls within this sort of definition of regularly harboring, keeping, or exercising, if we're not talking about the type of kennel or boarding facility that's at issue here? I mean, doesn't that seem like a pretty classic illustration of owner under the statute?
Well, and so, and that's kind of what the Folad versus Quilco case analyzes, is what makes a person a statutory owner of a dog, and this idea of control. And that goes back to kind of where I was going with the third foundational point, is what the General Assembly intended to accomplish by passing this statute. It is to broaden liability, and yes, it does sweep in statutory owners. There's no provision in there that then says statutory owner, that title owner is immune to liability from statutory owner. This idea is about responsibility for the dogs. And let me back up a little bit, and I guess a better way to explain this is what they were intending to do is plug a hole in the law. You have dogs running loose. The General Assembly talks about this. There's dogs running loose. They bite people. There was not a prior bite, so there's no notice of prior vicious propensities. And so you couldn't hold the owners liable, or whoever has control of the dogs liable. People were falling through that hole in the law. So the legislature's goal is to plug that hole with a new statutory rule that if you're responsible for a dog and you let the dog run at large, we're not going to apply the one bite rule anymore. You're going to be liable regardless. So, the question then is, I think your follow-up question to what you're asking is, doesn't that mean you're getting rid of the one bite rule? That's their argument.
I'm trying to think through who exactly regularly keeps a dog who's not a title owner of a dog. And
Well,
isn't that a boarding facility going to be?
It
seems almost paradigmatic to me.
It could be. It could be a boarding facility. It could be a groomer. It could be your neighbor.
Could be
If
your
your
brother,
dog goes over
yeah.
to your neighbor's house and you feed it, it could be a whole lot of people. And so if you are a person who falls with that umbrella that you have responsibility for the dog, in Folad versus Quilco, it was a liquor store. Now, we would submit that the question of who is a statutory owner is a question of fact. This boarding facility held these dogs for 44% of the time. What is the line? If they'd been boarded 25% of the time, is that, as a matter of law, a statutory owner? If it's 56% of the time, is that a statutory owner as a matter of law? Folad looked at, is the dog part of the face of the business? It was a shop dog for a liquor store in that case.
You said as a matter of law, so it's for the court to decide?
Well, and that's a question I explore in my brief is.
I know, that's why I was asking.
Right, exactly. So that's a hard decision to make as a question of law, because the Folad case goes into a whole lot of different factors that they weighed. And at some point, the court has to make that decision about whether or not, this person has a certain degree of control where, they become an owner. And that's really, I would submit, a fact question and not a question of law.
Well, is it really a fact question? It seems to me it's a mixed question, right? Because typically, I mean, there's no dispute over the amount of time that these dogs were being boarded.
There's records of it, right?
Yeah, there's records on it, so you're not going to argue, well, no, you got the number of days wrong. I mean,
Right.
you've already mentioned in your argument the percentage of time
Right.
that these dogs stayed at this particular kennel. And so when you have facts that everyone agrees to, and you're applying agreed facts to a statute and say, does it fit the statutory, we've always said that's a mixed question.
I guess that would be fair, but there is still a
And
way.
we've allowed courts in that circumstance where everybody's agreed on the facts and says, does this meet a statutory definition? We're going to say that the court can make that kind of determination because there's really nothing, it becomes more a law question at that point.
Well, if the only question were a strict mathematical percentage of X number of days, you might be able to get there. But I would submit to the court that FOLAD looked at a whole lot more than just the amount of time the dog spent at one point versus the other. The other thing that I'm going to keep steering back to is that we get bogged down in this issue of ownership and control when the legislature, first of all, if you have common law liability for a known vicious dog, the fact that I take my dog who I know to be vicious and board it with a facility and maybe create a statutory owner does not, there's no legislative intent to then shield me from liability.
Well, let me go back to the issue about whether or not common law was supplanted here in this case. And I agree with the notion that courts should be careful of saying that the common law has been abrogated by a statute unless the legislature specifically tells us that's intention. But if you look at A1 of the statute, that is a broad creation of a duty. To me, it looks like it fully supplants this first free bite common law principle that we had up to this date. I mean, how do we not read that as fully supplanting the common law? If you look at what A1 says, which just says the owner of a dog has a duty to keep that dog under reasonable control at all times and to keep that dog from running at large.
Well, because this is a rule for cases, like I said, the legislature's idea was to plug a hole in the common law. We're talking about a responsibility to keep control of your dog and keep it from running at large at all times. The case that's going to come up, if your honors go in that direction, the next case that's going to come is a person who has a dog that they know is vicious and they're walking it on a leash and it attacks somebody. It's not running at large because it's on a leash. All of a sudden, are we going to hold that as long as you've got are we going to have a leash rule that immunizes the dog owner even though they know that it's a vicious dog? I would submit that this policy choice that we get to, when you look at the common law decision to own a dangerous dog, the thing to remember is that's not a decision that the groomer can make. That's not a decision that Chasing Tails can make. That's not a decision that the neighbor makes while you're on vacation in the Bahamas. That is a decision that the title owner makes.
Yeah, but can a kennel make that decision? I mean, the way they do that is they ask questions to the owners and say, hey, are there been any previous bite instances? They take the dogs in initially and let them see how they socialize with other pets before accepting them for boarding or kenneling. That's how they do that. So they are in a position to do that. In fact, don't we expect kennels to bring that expertise to the service that they render?
And I'm getting short on time, but Your Honor, would that not be a comparative fault question rather than a question where we just say, okay, if you don't ask these questions before you take responsibility for the dog, then you don't have any recourse against the title owner who knew the dog was vicious and didn't warn you. At that point, it's almost like a contributory negligence standard, and we'd submit that that's not what the legislature intended in passing the statute.
Thank you.
Good morning. May it please the court. My name is Richard Montez. I'm an attorney with the law firm Memorial Owing the Party. I represent the defendants, Paul and Leanne Gravette. I'd like to begin by first addressing this question about whether or not it is a question of fact regarding the ownership of the dogs. As the court pointed out a few minutes ago, it is a legal question. What does it mean to have regular control of a dog? The facts in this case are not disputed. So can a jury look at these facts? Can any reasonable jury look at these facts and find that they are not in regular control of the dog? Your Honor pointed out before, if not in this instance, then in what instance would somebody ever be defined as regularly harboring a dog? They took care and control of these dogs for 134 days. They're responsible for feeding.
You're aggregating the days, too. It's not like they kept them 134 consecutive days. They kept them 4 or 5 days, then they went home for a week, or maybe 2. Then they kept them 7 days, and then they went home again. Is it fair to aggregate them and say, oh, they kept them all this time, so they obviously keep them regularly, rather than say, well, they kept them for little bits of time, several times.
Certainly in defining what it means to be regular, you can look at the period and length of time. You can look at whether or not they had exclusive control over the dogs. You can look at the level of sophistication of the individuals involved who are now keeping and maintaining those dogs. But in this instance, where they've had those dogs over a period of time, but a period of time that included 134 days, they have accepted that responsibility. They have contracted for that responsibility to care and control for the dogs. And that is why, as a matter of law, they can be considered owners. With respect to whether or not the common law has now been replaced, the key to determining that is to first look at, does the statute change the common law? Second, does the statute create new rights and responsibilities and duties? Third, does the statute create liability where there otherwise was not? On each of those questions, the answer is yes.
Limited, and the language of the statute, the owner of a dog has a duty to keep that dog under reasonable control at all times and to keep that dog from running at large. It's in a part of the statute related to animals running at large. Earlier provisions in the part relate to, for example, keeping livestock from running at large in the state. Isn't the statute designed to deal with a fairly narrow circumstance of dogs running at large, which really has nothing to do with the facts in this case?
But during the legislative debates in the judiciary, this very question about what do you do about a kennel owner?
What about the text of the statute rather than the legislative history? And looking at the text of the statute, looking at the part language that it appears within, which the legislature placed it in as part of the amendment, which deals with animals running at large. Under the text of the statute here, what tells us that this has anything to do with the type of circumstances we're looking at in this case?
You have to combine A1 with the definition of owner. And A1 requires an owner to exercise reasonable control. And then it defines what an owner is. An owner is somebody who regularly harbors the dog. So the goal of the statute, by its plain language, was to impose upon people who have accepted responsibility for a dog the duty to care and control them. And in fact, that's exactly what was asked of Senator Jackson, who introduced the bill in the legislature during the debates in front of the Judiciary Committee. He was asked by Senator Hudson, doesn't it seem unfair that you would then hold liable a neighbor, a friend who decides that they're going to watch the dog, or a professional who decides they're going to watch a dog? And Senator Jackson responded in saying, no, that's the goal of this. He, in fact, gave an example of somebody going to the Bahamas and said in that instance they would be liable because what we want to do is we want to ensure that that individual then is responsible, not only has accepted responsibility, but then has the responsibility to control the dog.
Under your understanding of the statute, if I train and raise vicious dogs, at least anybody that's outside of my family, and my mom comes and takes the dog on a daily basis when I come to work, and it's in her possession and it gets out and injures somebody, I'm off the hook completely in terms of liability. Only she's liable under this scenario?
So in that scenario, if you look at the way the statute is put together as a whole. So there's two questions. Is number one, whether or not the statute has replaced the common law in total. A secondary question, which this court only needs to address, is whether or not has it replaced it in this instance involving two owners. Your example involved an innocent third party. So the question which the court faced in Searcy was a more narrow question. In this particular instance, did it replace the common law? But I think you can go back and you can look at the entire statute and ask whether or not it replaced the entirety of the common law. If you look at how the statute was put together, it is defined as, the title of the statute is liability for injuries caused by dogs, exceptions, limitations. A1 talks about reasonable control. Then they added back in the vicious propensity grounds in talking about an individual who had a dog in their own home. And then there's another section that lays out 5 exceptions to the statute. When deciding what to do, the court has to look at whether or not the legislature has now occupied this space, has created new responsibilities, new duties, new obligations. And that's exactly what the legislature did here. They changed the common law. They created a new class of owners and defined who those owners are. They did that because they wanted to place that responsibility on individuals who have accepted that responsibility. And in doing that now...
So in your view, has this statute totally replaced the common law?
I think the court could find that, but it's not necessary for the court to find that with respect to two owners, to two statutory owners.
Okay.
If the court doesn't want to go that far or feels this case doesn't raise that issue, it doesn't have to, but I believe it can say that. The
Okay.
other way to look at this is also to say, what if, in this instance, the dog had attacked, as you suggested before, an innocent third party? Would we not consider chasing tails and the employee liable to that innocent third party? Yes, we would. That was the whole point of the statute. The whole point of the statute was to place them in that responsibility, to give them the control, to give them the obligation. So of course we, in that instance, given these facts, would say, yes, they are responsible to a third party. This case involves a question as between two people who have now been given that responsibility under the statute.
Counsel, I'm following your argument in terms of why the responsibility is being added to chasing tails. I'm struggling still a little bit to see why it's eliminating the responsibility for the title owner. I mean, the title owner is still also an owner of the dog. How is this eliminating their responsibility?
Because it's now coming in and saying we're changing the entire scheme. We're not looking anymore at vicious propensity. We're talking about reasonable control. And if an owner, the title owner, decides that they're going to go away, but they decide to entrust their dogs to trained professionals, it is now on those trained professionals in the exercise of their duty, in the exercise of the contractual obligation to the owners
So going back
fulfill
to
that
the
duty.
original hypothetical, then you would say the title owner of the dogs are off the hook. Mother-in-law or mother comes to care for the dog while you're out of town. The dog bites someone while in the mother or mother-in-law's care. The owners of the dog are off the hook under your reading of the statute because they are also qualify as owners.
The statute now defines it as reasonable control. So the question would be, did they exercise reasonable control?
Wouldn't that be a situation where the statute just didn't apply and the common law was still there and supplied the rule?
That's why I said before, I believe if you look at in totality, you can decide that in its totality, the common law has been obviated.
Well,
But
so
in order to reach
I
that
understand your
conclusion-
position that the common law has been obviated because that wipes out any possibility of the common law coming into play when, if the statute doesn't apply. But as Searcy showed, there can be situations where the statute doesn't apply and the common law is still, and they said the common law was still in place for those. Isn't that right?
So Searcy just looked at that narrow circumstance of in the home and decided that in the home, the common law had been completely replaced. And it did that because it decided that as an exception to this new rule that they created, it was going to bring back the one bite rule within the home. And then it had the other 5 exceptions that were listed in the statute. So it found that because they specifically came up with a rule within that context, then they've eliminated the common law. And again, here what you have is you have a creation of an obligation as to owners. And that's why once the legislature has chosen to step in and create a new obligation and a new rule, at that point then, the courts need to tread more carefully, because the courts now have to look at the legislature is setting the policy. The legislator is setting the policy as to who has responsibility vis-a-vis the dogs.
I mean, but you would say at the time these injuries were afflicted, that your clients did fall within the definition of owner, correct? I mean, they are someone that regularly harbor or keep or exercise control of their dogs.
Yes, they are an owner.
So, I mean, to me, to say that the legislature intended that an owner would completely be without liability, they would put under subsection B another exclusion for if another owner was involved, but it's not there. So, I mean, how can we read this immunity for an owner into the statute?
Because at the end of the day, the statute creates an obligation, and by permitting a common law claim, you are then eliminating the very obligation that you just created. Kennel owners and their trained assistants are in the best position to control the dogs.
Counsel, there's a number of jurisdictions that have been cited in the briefing where there's a statutory provision, oftentimes more specific than what we have here, or strict liability provision. Are there any jurisdictions that you can point us towards where there is a common law-based claim where the jurisdiction has said, we're not going to allow for the common law-based claim based upon our statutory reform imposing liability on whether it's a veterinarian, kennel, boarding facility? Has any jurisdiction reached the conclusion that you're asking us to reach today in light of a common law-based claim rather than a strict liability claim?
Right, so we cited to the Belcher case in Florida. Florida did not involve, though, a veterinarian. It just involved the question of whether or not the statutory creation eliminated the common law in that instance. But none of the cases that the plaintiffs have cited have gone through the analysis that Tennessee would require in order to determine whether or not the common law has been replaced. And that's where we go back to, well, what is the analysis? Did it change the law? Yes, it did. It intentionally changed the one-bite rule. Not only by statutory language did it do that, but also by every expression within the hearings and the debate on the bill. That was the clear plan of the bill, was to replace the one-bite rule. Did it create new rights and responsibilities? Yes, it did. It created new rights and responsibilities and a new class of ownership. Did it create liability where there otherwise wasn't? Yes, it did. It created liability on those. And so now what we have is we have a kennel worker who's been entrusted with the responsibility to care and control the dog. At the time, there is absolutely nothing that my clients could have done to prevent the injury. Even if on day one they had advised that there was a potential incident involving another animal or another family other workers when these dogs were puppies, it would have no impact whatsoever on what happened on that day.
Why isn't that significant? I mean, couldn't that affect whether, and if you walk in the door and say, hey, my dog has previously attacked people, might that impact how a boarding facility would handle a dog that they took, or whether they would take the dog at all?
Under the facts of this case, after 134 days, they know these dogs. They have been in control and care of these dogs for 134 days. There's absolutely nothing the Gravettes could have done on that day to have prevented it. And to impose liability on, there is no public policy that justifies or that would warrant or that would require imposing liability on the Gravettes for the failure to protect the very people that they hired and contracted for to train, socialize, and care for their dogs. And for that reason, the trial court's decision was correct, and this court should affirm summary judgment on behalf of the defendants. Thank you.
Thank you.
May it please the court, the closing sentence, they say there's nothing that they could have done to prevent this from happening. There's no public policy that is served. That's where we come from with the common law. What they could have done to prevent this is when they realize that they have a dog that is vicious, the common law choice is the dog has to be put down. The dog has to be sent away to somewhere. The dog has to be secured and confined and not exposed to people in the public who can be hurt. That's the public policy. If you own a dog that you know is vicious and you point that loaded gun at people and they get hurt, you own those consequences. And tort law is about deterrence. We are deterring people from continuing to do what the Gravettes did and send dangerous dogs out into the community where they hurt people. Your Honor, you had asked a question about the aggregate nature of these days, 100 and something days in the year. The statutory definition of owners, that's one thing that we haven't talked about that you should look at. It says an owner is a person who regularly harbors, keeps, or exercises control over the dog, but does not include a person who, at the time of the damage, is temporarily harboring, keeping, or exercising control over the dog. The court's going to have to explore the meaning of temporary.
Well, yeah, right, but I mean, to me, that's something like, here, hold this leash for a second. It's not, we're bordering the dog for a weekend or a week or whatever. I mean, right? I mean, isn't,
You know, that's one fair reading of it.
Yeah,
But,
okay.
you know, the other thing is, I mean, the dog comes back to them at the end of the day.
Counsel, are there any disputed facts in this case? Or are the facts entirely in agreement here, and it's just a question of how they apply to the law here?
I think the facts are in the record are pretty clear for summary judgment purposes. Now, there's weighing of these facts and what does this mean to be an owner? Where do we cross the line? But the facts themselves are fairly undisputed. The other thing in my time that I just wanted to point out is you have to be careful about getting rid of one harsh result, the one bite rule, and creating a new harsh result. The statute, as you observed, doesn't reach, you know, it's dog's running at large, doesn't really reach a dog in FOLAD where it's inside the liquor store. It's on a leash. It's at the dog bark park. If we eliminate the common law, we have a lot of things that this law does not apply to, and we expose people to a harsh result.
Thank you very much. Thanks to both of you. We'll take it under advisement. Would you call the next case, please?
BFI Waste Systems of Tennessee LLC versus Central Tennessee